Good evening, everyone. My name is Furqan Mohammed. I'm an attorney and founder of MST Law, which is a law firm in Elmwood Park. I've been practicing law for about 8 years now, I guess maybe 7.5. I started my career at the same firm Randy did, at that was your second firm.
Right.
A firm called Perkins Coie, which is nationally recognized as a firm that works with tech startups, everything from Facebook and Amazon to Google, a lot of those tech companies that you hear about now. Perkins Coie is known as one of their chief primary legal counsel. So we got a lot of experience with, everything from the Fortune 50 company to startups on a shoestring budget who have just ideas. Perkins Coie was one of those firms that was working with startups very early. They kind of invested in those startups very early. So both of us got a chance to work with companies like that. So hopefully from today's session, you'll get an idea of what are some of the things to look for from a legal perspective. And then obviously we'll break down the legal perspective into IP and non-IP legal pitfalls. This is our second year presenting, as Karen mentioned. Last year it was a smaller showing. Thank you all for coming out and braving the cold weather. I know that we're clearly moving up in the popularity. We now have cheese, so that's a huge. That's when you know. Yes, an unopened bottle of wine. That's how you know that you're moving up. You now can afford to have cheese. So. Like I mentioned, we've worked with everything from the Fortune 50 company to the startup on a shoestring budget. And personally for me, and Randy can weigh in on his own, I always found the latter more exciting. Being able to take a startup from the very early concept, helping them grow, helping them develop their niche, helping them create a market, getting into the market of their choice, helping them carve out a niche for themselves, generating revenue, hiring people, making national news. That was more exciting to me personally than working for even the companies that we hear about all the time, the Facebook and the Google. So, Randy probably would agree with that sentiment.
Totally.
But we find that really one of the best parts of what we do on a day-to-day work as lawyers. Now, every lawyer will tell you that we have a best friend. The best friend is called the disclaimer. So let me start out with the disclaimer. Don't take anything that we say today as legal advice for you to take back to your company today or tomorrow and start operating off of that. This is just to help you understand. Maybe if you take nothing else from this presentation, hopefully the one thing you take away from it is these are the types of issues to look out for when you know you need to talk to a lawyer. So every lawyer's worst enemy is pre-drafted template agreements. So we get them all the time. Somebody will come to us with a legal issue and we'll ask them, well, do you have any paperwork relating to this issue? And they'll give us a LegalZoom document, or they'll give us nothing. So LegalZoom or nothing. Sometimes the LegalZoom can actually hurt you more than it can help. But those types of issues, are things that we deal with. So hopefully from today you'll get to understand these are the types of things to look out for. This is when I need to definitely talk to an attorney because there's some thorny issues that can come up with it. And I think a concept you will hear early and often is prevention is easier for us to do than curing something. So cure is where a lot of money gets spent. Prevention hopefully is a more modest investment for you as the company and can save you a lot of headache and heartache down the road. So let's talk about a little roadmap here. We've broken down pitfalls into two categories. We have, this is very genius I think, non-IP pitfalls, and we have IP pitfalls, right? So there's intellectual property related pitfalls that I think we'll spend the bulk of this conversation on. But before we even get into the IP ones, we'll talk about some non-IP that I think apply across the spectrum. So obviously this is very broad. We are by no means going to cover everything in the non-IP realm or even the IP realm in 45 minutes. There's a lot of things that can be said, a lot of courses that can be taken, a lot of things that we can delve into. I've generally seen, and I'll tell you this just from experience, if you're in a particular industry, be it restaurants, digital media, or marketing, oftentimes the issues that come up are more common in certain industries. So my restaurant clients tend to have a lot of employment-related issues, wage hour issues. They're a startup restaurant chain or restaurant concept. More likely than not, their IP issues are usually not the biggest thing on their mind. Their issues are usually employment-related, operations-related. How do we prevent employment claims, things like that. So for people who are starting a company, I always recommend try to find a mentor who is in your industry in particular, because they'll be able to guide you through some of those early headaches that companies in that industry have. So the concept of what is a startup. So now I think it's taken a very different meaning than what I think a startup is supposed to mean. Marco, right?
Yeah.
What do you think about when you think about a startup? What comes to your mind? First vision in your head, in your brain.
Business from zero, like giving opportunity from ideas. Like.
Okay, so just a very high-end idea, some kind of concept, right?
Yeah.
It may be something that's groundbreaking. It may be the next Facebook. It may not, right? When I talk about startups, when we talk about pitfalls, we're not just talking about the next Facebook or the next Amazon. We're talking about Joe's lawn mowing company to the small restaurant that's starting up from scratch. These types of issues apply to everyone across the spectrum. So, when you think about startups, I think younger folks especially think about these unicorn companies as the type of startup, but really, a startup can be anything. So, and these issues will apply across the spectrum. So now, let's further break this down. So we have IP and non-IP pitfalls. Within the non-IP pitfalls, I usually find them most prevalent in two different subcategories: corporation-related, employment-related. So when you think about non-IP, these are the two categories that tend to have the most legal issues related to them. So before we even get into those two categories of legal issues, I want to just at least mention the non-legal pitfalls, which is just a failure to follow common sense. From what I've seen, generally speaking, I feel like there's like this well of common sense, like a pool of common sense, and it seems to be drying up in more recent years. So, I always tell people, look, before you even talk to a lawyer or talk to an accountant or talk to anyone, have you sat down for yourself with your founders, with your business partners, and talked through budgeting, for example, right? Because one of the most common reasons why every company fails is they have this astronomical budget in year one, and they just clearly can't, sustain that kind of, budget. Part of it can be subsidized through your own personal finances, but at a certain point, you're going to get tired of putting your own money in if it's not generating enough revenue. But you'd be surprised at how many people come to me and they haven't even looked at or talked about their budgeting. They haven't looked at their business plan. They don't really know exactly yet what they're doing, but they want to start incorporating and start doing, investing money into the business. And I tell them, well, look, I'm happy to talk through the issues, but come back to me when you have something more concrete, because I don't want you to create this corporation and go through this whole process when you haven't even really thought out how you're going to move forward with the business. So before you even get into the legal stuff, think about the non-legal stuff. Think about the budgeting, the operations. Those are usually the most common reasons why companies fail. Legal budgets, and I'll even throw in here, when I talk about accounting and operations expenses, budgeting, in an ideal world, I would love that my clients have this infinite legal budget, but the reality is they don't, right? No one has $50,000 to throw towards legal expenses right from the get-go, and frankly, I wouldn't even recommend that. I think that money is better spent on marketing, on maybe hiring a salesperson. Generating the interest and the revenue is probably a better spend than trying to get all your legal stuff 100% right from the get-go. I would love to have somebody who wants to spend X amount of $1,000s on a legal issue, but I tell them, that's not a very good use of money, especially in the early stages. Down the road, there's certain things that we can clean up, there's certain things that we can do to kind of offset that, but in the front end, you don't have to be perfect. So don't think like, oh, well, I need X amount of thousands of dollars to start up. Really, do the basics, talk to a lawyer, do as much as you can, do a lot of Googling. Obviously, Google the lawyer is there to also at least give you some basic information. Don't take that at face value, or don't take it beyond its face value, but make sure you talk to a lawyer after that, but at least be well read on what types of things you might be able to do on your own. Corporate pitfalls. So like I said, when we talked about that roadmap, non-IP and IP pitfalls. So now within that non-IP, we had talked about the two subcategories, right? Corporate, employment. So let's talk a little bit about the corporate pitfalls. So I think the first presentation was supposed to be the importance of incorporating, or the best best practices with incorporating your business. I think that's probably going to be a better suited venue for you guys to learn about what type of structure works best for you. You know, there's a lot of different structures: LLCs, S corporations, C corporations, LLPs. You know, there's a lot of ways you can do it. For me as the lawyer, I usually defer to the accountant. I think most of those issues deal more with taxes than they do legal considerations. Whatever you decide with your accountant, we can help execute. So I tell folks, I'm happy to talk to you about the incorporation issues, but your accountant's probably going to be a better suited candidate to discuss those kinds of incorporation issues once you decide on that structure, because it usually deals more with taxation issues than it does legal issues, because we can always work with whatever structure it is to help you achieve whatever goals you want. So
next month's session too, by the way.
Oh, perfect. So next month's session, you guys already know what it is.
Yeah.
You know, whatever structure you choose, know that the main purpose of that is liability protection, right? So if there's Joe's refrigerator repair company that's not incorporated and Joe's refrigerator repair company that is incorporated, and let's say Joe works on a fridge that then blows up and causes a fire in the house and causes $50,000 in damage, if Joe is not incorporated, Joe is liable personally, right? Joe has to now pay out of pocket. If he has a house, whoever was faced the damage in the house can go after his house because he doesn't have that corporate structure protecting him. The Joe's refrigerator company that did incorporate, the company might have some assets, but his personal house, his personal assets would not hopefully be brought into the lawsuit. So that's why we incorporate. Whether you do an LLC, S corporation, C corporation, that's the primary reason why you're doing it, right? So you don't want to start a company and take on any liability on your personal name, because then you're going to be, if something goes wrong, you don't want to be stuck on that personally. So incorporating is really for liability protection. Now, once you've incorporated, that doesn't mean you can just throw that book, you know, in the back closet or back drawer and never look at it again. The reality of it is there's a lot of things you need to do to maintain that corporate formality. So if you want to stay as an LLC, stay as a corporation, you have to do certain things. You have to follow certain protocols to ensure that you don't lose that protection, that liability protection. So there's two interrelated issues. Following corporate formalities. So every year there's requirements for you to maintain your status, filing an annual report, maintaining corporate minutes, updating the documents as your business evolves. Those are all things that you want to make sure you do. Commingling of funds is actually a legal term. So what that means is if you have Joe's refrigerator company and the money that comes from that company is all being put into Joe's personal bank account, that's a problem because you're not separating your personal assets from the business assets. So if that fire happens in the house, well, the judge is going to say that you didn't maintain a difference between the corporate assets, the personal assets. So anything that you have personally can now, again, go on the hook. So when you commingle funds, that's a bad thing. If you have 4 different businesses, you need to keep them separate. And especially for small businesses, a lot of them kind of oversee that, or I guess don't follow that because there's such little money being generated, they just put it straight into their personal bank account. That's a huge problem. So I know there's headaches with having multiple bank accounts, but that's the reason you have the multiple bank accounts. Now, the legal term for these, if you fail to follow the corporate formalities, you fail to separate and distinguish between corporate funds and private funds, it's a legal term called piercing the corporate veil. If you Google it, you'll see a lot of information on it. It's probably one of the most litigated issues in corporate law. And what they're trying to do is pierce that corporate veil to go after somebody's personal assets. So if you see that term in practice, if you Google it, you'll see a lot of information. There's a lot of lawsuits. That's usually what they focus on when there's a corporation that's a defendant. You always want to have the possibility of going after somebody's personal assets, right, as a plaintiff, than to just take the corporation's assets, which may not be as much. Another early pitfall, failure to invest in an operating agreement or founder's agreement. Now, this isn't going to be perfect from the get-go, but I do always tell people at the very least, before you even get an accountant, a lawyer, at least sit down with your business partners, your founders, talk through some of the most common issues. So if you Google common issues for founders, there's a ton of resources out there. I know that UPenn did a sample. You don't need to come to the lawyer first. Google it yourself. You'll see some very common issues. You guys should, as you and the business partners, should at least start talking about those types of things. So some common examples of issues that I've seen where they don't have the founder's agreement or an operating agreement, job responsibilities and duties, who's going to be doing what. How is the decision making going to be? Do you need both partners to consent to a $5 Coke purchase, or do we have some kind of discretion to, for purchases under $100, any partner has the right to make it? For example, the decision making, right? Do we need a unanimous decision making on everything, or just the major issues? Assignment of rights. So I've had issues where one partner will say that certain discoveries that he or she had are not involved in the corporation. Those are separate. Those are mine. So I've had disputes related to who's the true holder of the invention between founders. I've had issues where founders, 6 months, at the first, on day one, both founders are, gung-ho, ready to go, all in. 6 months later, one of them gets married, one of them has a change of circumstances, can't really focus on the business full time, right? Well, now what happens? Are they still 50-50 owners? Are they not? That's the types of issues that come up between founders that before you even get a lawyer involved, Google it, talk to your founder, talk to your business partner. You'll see some very common issues that need to be discussed between the partners. And then at some point, I would say, put it down on paper, come talk to a lawyer. It'll be much less headache for you, much less legal expense as well. So again, when I have somebody that comes in that's just first thinking about this issue, I tell them, look, I'm happy to do it and charge you X, but I know I can charge you Y, which is much less. If you go back, here's 3 or 4 resources, read through these, talk to your business partner, come to some agreement to the extent you can. I'll help you memorialize it. Employment issues. So the second subcategory that we talked about, employment-related pitfalls. So a lot of these deal with adhering to your own employment agreement. So I've had issues. I think Randy mentioned 3 times this week he had this issue. An employee came up to Randy and said, hey, I have an idea, but I don't know if it's encompassed within my employment agreement with my current employer. It's a very gray area. There is no right or wrong answer necessarily, but it's a very case-by-case, fact pattern assessment. So if you have an idea, number one, do you have an employment agreement that you're bound to? And if so, does that invention already fall under that employment agreement where your employer already technically could own it? You may have your own non-compete. So I write non-compete here, but non-compete is usually the most common issue in an employment agreement. Do you have a non-compete where you can't compete with your current employer by opening a new company that's trying to compete with that old business? Very common issue. I've seen a lot of startups go under just because they had the great way to innovate what their employer was doing and take it a step further. Lo and behold, they have a non-compete that said for 2 years you can't really work in this industry if you leave on certain terms. Well, now they're stuck in a lawsuit against their former employer, and a lot of companies fail because they don't have the resources to fight a litigation, right? Even if there is no employment agreement, there's something called a fiduciary duty. Most, if not all, employees owe a fiduciary duty to their employer. Are you breaching that by taking an invention that you made while working at the employer and using that for something that's benefiting yourself, whereas the employer should have been the one benefiting from it? So that's for your own employment agreement. Then there's also the hiring help section where, this is by itself a very long, extended conversation we could have someday. But when you hire somebody, are you hiring them as an employee or an independent contractor? It's a very gray area. There's, I think, a 20-factor test that you can run through to see how somebody should be categorized, whether they're rightfully categorized. And if they're not, the IRS could come back down the road, or Department of Labor could come back down the road and say that you now owe all this back taxes and all these back wages for somebody that you improperly categorized as an independent contractor when they should have been an employee. Within the employee category, there's exempt versus non-exempt. Again, I'm giving you very high-level stuff. Don't think you're going to take all this home. But there are certain categories where people can be exempt from overtime wages, certain categories of employees that can't be exempt from overtime wages. I see this a lot, like I said, in the restaurant industry. For those people, I've seen lawsuits that get filed, and that causes the company to go under because they haven't paid. They apparently haven't paid all the back wages that were owed. So whether they knew of it or not, those issues come up all the time. If you're going to be hiring somebody, employment agreement, vesting schedule, if you're offering them equity, those are the types of things that you want to look for when you're hiring somebody. Last one on this list, which I'm using kind of intentionally to segue into Randy's section, failure to maintain trade secrets. So Randy will talk about, when he talks about IP, there's patent and there's trade secrets. We'll talk towards the end about the trade secrets, and I'll weigh in a little more at that time.
Thank you. So we're going to transition to the other category here. Do you want to do the, oh, that's me. There you go.
That is you.
That is me. So we're going to switch over to the IP side now and talk about intellectual property and why startups like those, why they want to have those, what value do they bring, and then actually how you execute on those, how do you decide what you need. So the first question, of course, is why do it? You're probably sitting there as a startup thinking, I don't have a ton of cash. Why am I going to put cash into a lawyer that's going to do this stuff for me? There's probably a longer list than this, but the basic reasons you'd want to have an IP portfolio is all about bringing in the revenue later on. So if your business plan is to attract investment dollars, tough to do that without an IP portfolio because an investor will look at your company and say, well, you don't own anything. You're not making revenue. You're not selling anything yet. You don't own anything, what am I going to get if this goes south? And so an IP portfolio is a great thing to use as leverage in an investment deal. Same thing, bank loan collateral. So bank loans often have to be collateralized. You have to put up some kind of property to guarantee that you'll pay it back. And if you don't pay it back, then the bank takes that property, right? That's how mortgages work. That's how your car title works, all that sort of stuff. Well, in the startup game, we don't use house title or car title. We use IP portfolios as the collateral. Which is actually a great thing for your startup because if everything goes south, you don't need the IP anyway, right? So sure, go ahead, bank, take it over. You know, couldn't pay back the loan, and you get some IP at the end of the game that I'm not going to use at all. At a higher level, you know, it shows that this isn't just a hobby for you. It's not just I'm tinkering around and I came up with an idea and you know, why don't you pay me for it? Well, that's a short conversation with an investor. They'll say, that's great, good for you. When you have something like concrete, come back and we'll talk. Filing IP, even if it's not through the process yet, is a great way to show that it's a business and not just a hobby. And that legitimacy is going to open up a lot more doors than if you just start knocking and saying, I have this idea, can't we work together? Showing that you filed IP to protect that proprietary space shows that you're serious about it. On the other side, if your technology is very broad and you file IP on the broad technology, maybe your business plan only deals with one portion of that technology, but there are other industries, other sectors, other applications for the technology that you don't have time or the interest or the resources to develop yourself. You can license that out to somebody else who does and actually get paid for not doing the work of developing that technology in that sector, which is pretty great. That's basically free money, right? I get paid to not do that work, which is always better than getting paid to do actual work. So that's a nice avenue to take to. Difficult to do in the real world, but that's potentially out there. It does happen. And this next one kind of goes along with that, the alternative revenue stream. So if it opens up doors for you, intellectual property opens up doors for you to monetize things that maybe are a little off center from what you're hoping to actually take to market. Finally, the kind of traditional ones, and I put these at the bottom for a reason, these are probably in the real world, the least used aspects of intellectual property. Everybody thinks about these, but they're really low in terms of what we actually do with intellectual property in a startup community. One, discourage competitors. So everybody thinks, oh, if I patent this, nobody else can do it. Yes, but to enforce that costs a lot of money. And so, you know, that's a problem. You can certainly send a nasty letter, I own this patent, and you can't do that. But you better be willing to back that up with a huge bankroll to pay litigators to march into court and enforce that. And if not, that letter doesn't mean much. Similarly, to discourage knockoffs. So, you know, if you have if you've spent time and money and effort in building your brand on a product that you've now, you know, started to sell through Amazon, wait 2 weeks and you'll see the knockoff starting to hit the same Amazon search results, right? Having IP allows you, especially in the Amazon world, to really discourage sales of those knockoff items. In very concrete way. Actually, Furqan and I are working together on a case right now where we're on the receiving end of a brand that's pumped a bunch of money into developing their product, and our client has tried to come in the back door with other goods, and we're in that fight right now. It's expensive on both ends, just so you know. You don't want to get there. So now that we've given you the why, what is actual intellectual property? And I've put up here a piece of a title to property. And the analogy I like to make is that intellectual property is sort of the property line, the boundary between what you own and what you don't own, what you own and what's in the public in this case. It's a good analogy. It's not perfect, but it serves the purpose. And here's what I mean by that. Intellectual property is your legal stake, your legal claim to the stuff that you've created and belongs to your company. Now, you can rent out portions of that property, right? That'd be, in the IP world, we call that a license. So we talked about that in the last slide. If you want to monetize it and not do it yourself, rent it out to somebody else so they can do it. That's fine. You can keep it all for yourself and put that wall as high as you can build it and keep everybody else out. That's certainly a legitimate use of intellectual property. But the analogy sort of fits, right? You own a specific thing. The government has said, yes, you own it. Nobody else can own it unless you give them permission to do it. They can't come on your land. They can't sell your product. They can't use your brand unless you give them permission to do it. So that's a good analogy for what intellectual property is. Within that, there's a bunch of subcategories, so I just want to very quickly go through those. Just a quick survey. The one that everybody tends to think about first is a patent. You know, that's Shark Tank has brought that to kind of the common discussion now of, well, do you own this? Is there proprietary stuff here? They ask that question a lot. Or sometimes they'll just say, are you patent pending, right? So this is shorthand for what they're asking about. Do you own government-sanctioned rights to that technology so that it is exclusively yours, you can control it for a limited time? To do that, there are several subtypes. We don't need to get into those, but they differ depending on, we'll throw in a mix of those into an IP strategy, depending on where you're at, what you're trying to do with it, what your life cycle is for product development and sales and all of that. And so my job is to kind of mix this, give you the right recipe of all those different subtypes of patents, depending on what your business goals are. The basic process is, you know, we file a patent. The government tells us if you get that technology, the ownership of that technology or not. We fight with them a lot. That's mostly what I do, is arguing with the patent office, trying to get you those rights, or rights that are at least close to what you need. And then after that is when you get into the enforcement space, where you can say, great, now I own a patent in this space. That means I can stop everybody else from selling, using, importing, all those things of this technology. Let's go on to trademarks. So this is kind of the second most popular. Actually, right now I'm doing a lot more trademark work than patent work. Trademarks protect brands, and from the consumer side, they protect the consumer's link between a product or a service and its origin. So who makes that product, who sells that service, who offers that service, where does it come from? It's a consumer protection kind of IP, but as the brand owner, as the product owner, you can use that to keep others from trading off of your brand's goodwill. So Amazon for selling retail products through the internet. If you use a different jungle name, I don't know, name another jungle. Anybody? Me neither. So, or let's use the desert, Serengeti for, you know, selling products online. Amazon's going to have a problem with that, right? Or you misspell Amazon, A-M-A-Z-O-N-E, Amazon. They're going to have a problem with that. So, you know, why are they doing that? Well, that's because they've put a bunch of money into their goodwill, their brand, Amazon, for selling stuff over the internet and delivering it to your house, and they want to protect that connection between their customers and their brand. So if you come along with Amazon for selling stuff online, you expect to get a nasty letter from Amazon telling you better take down the website or else. So on the flip side, as the startup company, I help companies identify what they're using as trademarks. What is it? A product name? Is it a service? Is it the company name? How they're using it, and I help them enforce that too. So let's look out now that we've gotten some trademark protection for you. Who is using a similar word, a similar name, a similar phrase, and let's see if we can get them to rebrand their product. That's always a fun conversation. So that's the trademark side of things. But again, it's a consumer protection base, so it's a little different than the patents. The patents is not protecting consumers, it's protecting the innovators. Here we're protecting the consumers so that they don't buy something thinking it was made by Johnson & Johnson, and it turns out, oh, it's Johnston & Johnston, right? That's not who we thought made this product. Copyright's sort of the third of the biggest IP sections. Copyrights protect creative works, so books, poems, computer code. They have to be outside of your head, though. If it's just in your head, it doesn't count. You have to have it on some kind of the magic word in the legal community is a tangible form of expression. Saved on a computer, printed out on paper, on a canvas, you know, something like that. It has to be permanent, done. Doesn't mean you can't edit it, right? So every time a new edition of some 18th century literary work comes out, they've edited it. Like I just read, they changed some wording in Anne of Green Gables, and they get to like redo a copyright on that now because they've changed some of the wording. So Doesn't mean you can't make changes. It means you kind of recycle that process. Copyrights can last for up to life of the author plus 75 years or something like that. They can last a long time. Long time. In fact, right around the new year, there's always a news article about here's all the films that are now entering the public domain and all the books that are entering the public domain. You're going to see all those movies on the cable channels constantly this year because they don't have to pay royalties to the authors anymore. Same thing for the books. So you go to Barnes & Noble or wherever you get your books from, you'll start to see Barnes & Noble editions of all these new books in January, and that's because they no longer have to pay royalties to the author or the author's family when they come off of copyright. So they last a really long time. These are especially good for startups that are in computer coding, app development, anything creative. Consulting businesses, so all of your materials can be copyrighted that you're giving in your speeches and presentations and workshops and stuff like that. Very, very powerful and very inexpensive, which is also really nice. The government filing fee for a copyright is like $55, so it doesn't get much cheaper than that. There's no way they're making money on it. Yeah?
Now that a lot of creative work is online, is
Yes.
it harder to police the copyright infringement?
So it's very difficult to police copyright infringement online, other than a few years ago, not more than a few years ago now, a new law was passed that you may have heard of takedown notices, online takedown notices. So if you are a creative and you post a photo online and Johnson & Johnson takes that photo and starts running ads with it, right? They start using your photo without your permission. If those ads are online, you can file what's called a DMCA takedown notice, which is basically an alert to their service provider, their internet service provider, that they're infringing your copyright and that the service provider has to take that site down, or else they're liable for the copyright infringement too.
Oh, wow.
Yeah. So because of that, it's a really powerful mechanism for even the hobbyist, the hobby photographer. One of the ones that went kind of crazy, I don't know if you saw the meme, but it's the kid who's clutching his fist,
Oh, yeah,
right?
I
And
that meme.
yeah. So the mom of that kid who actually took that picture had all these lawsuits available to her against all of the companies that were picking up on that meme, just assuming that nobody was going to come after them, and they used it to sell products and services and market their businesses. Yeah, not a good idea, right? So, yeah, copyrights can be powerful. Now, a lot of that deals with you've got to march into federal court, and federal court's expensive. So, before you send a takedown notice, it's probably best to consult an intellectual property attorney that specializes in digital rights, because that can get expensive very quickly. And you don't want to mess around with that, because if you make the threat and then back down, you may have waived your right to later go back to them and say, well, I didn't have the money then, and now I have the money, and they're going to say that. The court's going to say, who cares? You had your chance and you blew it. So it does get tricky on that. Trade secrets, so Furqan alluded to this, and we'll spend a little bit more time probably on this a little bit, but trade secrets, I sort of describe that as the catch-all category, so all the stuff that you don't want to put out in a patent, all the stuff you don't want to put in a copyright protection. The thing with trade secrets, though, it's sort of like the cat in the bag, right? Once the cat's out, it's really tough to call it a secret anymore. It's tough to put the cat back in the bag. So most trade secret work that I do, and I think you would probably agree with this, has to deal with your internal company's policies and procedures for who has access to what. So customer lists are often taken by sales reps when they leave one company and go to another company. It saves them a ton of time from having to track down contacts, right? A lot of lawsuits about customer lists being taken as protectable as a trade secret. So there's a lot of self-help, which is great. Self-help is less expensive than hiring lawyers to do it. And the best sort of summary I can give for it is make very clear to people that you bring in, whether it's contractors or employees, of what data you have that you consider a trade secret, limit their access to it, limit your backups of it, make sure that it's not on personal computers, it's on a company-owned computer, that sort of things. Because the courts will look at it and say, well, did you actually treat it as a trade secret? If you just sort of posted it online, even on an intra website, and didn't bother to password protect it, and any secretary, janitor, whatever that walked through your company had access to it, maybe you didn't treat it like a trade secret, and we're not going to help you protect it as a trade secret after the fact if you didn't treat it properly. Classic examples, like I said, customer list, vendor list, pricing, so your internal cost of manufacturing, all that stuff can be protected as a trade secret. Your sources for certain materials. Yeah, what else? What else do you?
The most
throw in
famous
that?
example is the Coca-Cola formula, right? So as the story goes, or as it goes, that to get the Coke formula, I think there's only 2 people that know it in the company at any given time. You have to literally go into the vault. Both people together have to go into the vault, open the vault, and the recipe is there. So what's the difference? When you think about differences between patents and trade secrets are perpetual, right? So Coke's formula never has to be made public. If you file a patent, you get 20 years of exclusivity, but then after 20 years, it's in the public domain. Anyone can now build off of that or use that. So a lot of companies make that decision early on. Should we patent what we have, or is it better suited for a trade secret? So recipes are very common examples of trade secrets because you never want to put them in the public domain, and you have to exercise certain discretion with how you disclose that recipe.
Yeah, that's exactly right. And that's a great point. Trade secrets and patents don't mix. So when I say my job is to mix these things together for a particular client, given their business needs, trade secrets and patents cannot be combined together. You can't protect your technology as a trade secret, and then when you think, oh man, it's about to get stolen, I'm going to file a patent on it. No, you can't. You got to make the decision on whether you're going to protect it as a patent or a trade secret before you start selling or using it in public. That's a no turns back kind of moment for you. So what you can't do is, like I said, try to keep something protected. The secret for the formula for Coke, if they decided in 18 whatever, we're going to keep it as a trade secret, and then realized, oh man, somebody stole it from us, and they're going to start up their own Pepsi company with the same formula, we'd better protect it as a patent. No, you can't do that. Patents are not backups for trade secrets, and vice versa. Part of the deal of getting a patent is you have to teach the world how to make and use the thing that you're trying to patent. So you can see how those are in tension, right? I have to tell everybody how to do it to get my patent, and I have to keep it a secret to make it a trade secret. The line between those two is not wide, it's not gray, it's one or the other. That's a black and white moment, and it's a choose one or the other, but you can't do both.
You know, when you talk about pros and cons of each, for example, trade secrets, there's actually nothing stopping you from taking all the ingredients listed on Coke's, the back of the can, and trying to recreate that in your sink or your own tub. So if you are able to come across the recipe and reverse engineer it, so to speak, you now have a recipe that Coke can't do anything about because you reverse engineered that. Patent, once you disclose it because you want that exclusivity. Trade secret, you can take any kind of recipe and try to recreate it, or any kind of trade secret, recreate it. If it's, assuming you didn't use their information, it's yours. So it's a common distinction between a trade secret and a patent, why they don't mix, how they're different, the pros and cons of each.
For sure. And so I think as a result of that, you probably won't be surprised that industrial manufacturing processes can be pretty readily protected as a trade secret. You know, if you limit access to the plant, if you limit access to, you know, what temperatures and pressures and whatever you're using to make that product, very easily can be protected as a trade secret. On the flip side, if you're selling a coat hanger, a new coat hanger, probably not a great trade secret, because all someone has to do is take it apart when they get it home and figure out how you built the thing. You know, that's maybe go with the patent route on that, right, instead of the trade secret. So more broadly, stuff you can reverse engineer, software code being one of them, probably not great for trade secret protection. Stuff that's, I have no idea how they made this, and it would take, you know, an army of people 100 years to figure it out. That's trade secret territory. That's awesome. That's great. You know, that's stuff we can very readily protect.
It's so common to kind of think about trade secrets as like a technical expertise or technical know-how. It's really anything. I think Randy alluded to this before. It can be a customer list, a operations manual, some kind of. It's really a trade secret is any advantage that you have, any advantage. So it can be technical, it can be non-technical, customer list. All that falls into an advantage that you as a business have. That's what you want to try to keep secret.
Yeah, for sure. You know, one of the weird examples that I like to pull out once in a while, there's a large company in Illinois, and I won't name names, but their legal team has trade secret negotiation strategies. So they send out, oh, you want to do business with us? Here's our contract. And when they get pushback from the other side's lawyers, they go, oh, okay, great. And they go to their manual and they say, they didn't like that term, so the next option I give them is this language. And then we float them that language. And so that manual, that playbook, right, if you think about it in sports terms, terms. That's the playbook for the lawyers. That book, that strategy guide is a trade secret. Could somebody figure it out? Sure, if they negotiated enough deals with that company to sort of fill in the gaps. But until that happens, that's a great trade secret to keep under wraps. So yeah, it can be anything. I think the technical definition of a trade secret is anything that gives business value. So it can't be valueless. It can't be silly and stupid. It has to bring value to the company. But I think any of those customer lists, legal negotiation tactics, all of those qualify as bringing value to the business. So why so many types? I've alluded to this a bunch already, but every business has a unique need. You have unique goals. You have unique technologies, and so not everything in that previous slides is going to give you the foundation to build your company to achieve that goal. And so my job is to listen to a client and what you want to achieve, what your technology is, and help you decide within your budget what's the right mix of these things and what's the timing of that. That's my job as your IP attorney. But ultimately, it's a business decision. It's a budget, it's a strategy, and it's execution. And hopefully, we can come up with a strategy that makes sense within your budget to achieve that goal. But you can't build a house with one tool, right? You need all those tools. They all do special jobs, and you can't interchange them necessarily. They work well together sometimes, and sometimes they don't. So you got to pick and choose the right tool for the job. I get asked about this all the time, typical patent processes and costs and timelines and that sort of thing. So most startups are in this R&D phase when I meet them, or maybe leaking into the provisional patent phase. And at the bottom you can see the typical costs and the typical government fees. The timeline is at the black line there. So with the 0 point being the filing of that first patent application, just for reference point. Typically I'm talking with companies as they're developing a new product or service to say, how are we going to protect this? What do we want to do? Most often for my clients that involves a patent. And so we talk very quickly about the cost to prepare and file that first patent application, and then what happens after that. So very high level stuff, the cost to prepare and file a provisional patent application, the very first patent application in the process. Typically $2,000 to $10,000. The government fees are usually under $500 for something like that. So it's not a horrible spend, honestly. If you're pumping in, tens of thousands of dollars on product development, that's not bad, right? The problem with provisional patents, or one of the benefits of them, depending on how you look at it, they only last 1 year. So it's a very short duration. The benefit of that is the government only takes $500 and they put it in their files and they don't do anything else with it. That's it. They just sit on it. Total secret, not in the database that any public person can find. Only your lawyer can find it in the database. So what it does is it can extend that R&D phase for another year while you're still considered patent pending. So that gives you the freedom to test the market with the prototype, to work with vendors that won't sign a non-disclosure agreement, all those sorts of business problems that basic contracting may not solve for you. This has to be filed before you sell or offer to sell or show it in public. So whatever it is, if it's a process, if it's a product, you cannot file a patent application after you've done those things. Sell, offer to sell, or show in public. And public is a very broad term. It means anything not under a non-disclosure agreement, basically. Even if it's, my parent company wants us to present on this. Well, if you're a subsidiary and there's no automatic confidentiality between your parent company and the subsidiary you're developing the product under, that's public, according to the courts. So you got to be very, very careful about that. Just because it's a friendly audience doesn't mean it's not a public audience. Trade shows is another one where these things get destroyed all the time. Showing it at a booth at a trade show, even if it's invitation only, even if you got to pay to get in, that's public. Pitching to an investor, even if it's a closed door meeting, that's public, unless the investor has signed a non-disclosure agreement with you, which they don't sign. So getting this on file ahead of time solves all that headache, takes all that anxiety away, and it doesn't cost all that much to get those doors open with little to no risk. The provisional patent is also nice because within this year, we can file multiples of these things. So as you refine your design, refine the process, make changes, test it, get market feedback, they say, we don't really like this feature of it. Okay, great. Your version 2.0, if you can get it done in that first year, we can file an additional provisional patent on that without any headaches, without any problems. We mash all those together when we get to the non-provisional patent, which is kind of when the thing is locked. The text is locked, the pictures are locked. You can't really make changes to it after we file this non-provisional patent here a year out. So again, value of the provisional gives you a year extra of R&D time. Doesn't count against you in your 20-year maximum term for patents, so that's nice too. And it doesn't cost all that much. When we get to the non-provisional, like I said, this is kind of your, okay, we're ready to go to market point. We have a product, we like it, customers like it, our distributors really want to put it on their shelves. Good, you're ready for this non-provisional patent filing. The cost here is big range because sometimes all we do is we take this and we copy and paste it and we file it and we're done. Sometimes you've said, well, we made these changes and kind of pivoted, and we've got to do some heavy lifting on the application itself before we can file it. Government fees are a little higher at this stage, and it really depends on what countries you want to go to and what countries you don't care about. So the government fees will float a little bit depending on what geographies you care about. And then the process there, this is one of the things that I get asked about all the time. So on average, 3 to 8 years to get through that patent pending phase, get in front of a patent examiner and convince them you have something that's worth a patent. So that sounds frustrating to a lot of my startup clients. What do you mean? From this point where we start talking, it could be a decade? Yeah, it could be. And I've worked on patents that have taken longer than that to get through the patent office process. It's a rigorous examination. They don't just rubber stamp stuff. They don't take our word for it that you've invented something cool and innovative. They really do a deep dive into what the technology is and what you're asking for. Because again, remember, you're asking the government for blessing to own that technology by yourself for 20 years. That's a big ask, right? We have I think, still a democracy that likes open trade and competition. And a patent kind of runs against that, right? Wait, I get to control this throughout the country, whether I want to make it or not. You can just shelve it if you want and stop others from making that product or using that process. You don't have to produce it. So that's a big ask, and so the government takes that role very seriously. And so most of my work for you, some here, most of it comes in this 3 to 8 year section where we are negotiating terms with the patent office on your patent protection. Like I said, it's very serious. After that, the typical cost should kind of make you do a double take there, but maintenance and enforcement. So that's when you start lobbing these as grenades against your competitors to say, you better stop selling that or I'm going to take you to court. Patent litigation is very expensive, very, very expensive, and it's going higher and higher. There are many choices to make. We don't have time to really get into those choices today, but just know that you don't have to spend $10 million to enforce your patent. You can easily spend it, and I've seen it, and it's not pretty, but you can certainly do it. And the government fees to maintain it depend on how long you want the protection. You can always bail at any time during that 20-year period and stop paying on it. And it also depends on your geography. So there are patent systems in about 160 countries across the world. Your patent only protects you in whatever countries you've gotten that protection in. So it's not like you can get your US patent and say, oh great, I can stop you in Europe from selling. Nope, you'd better have a European patent for that. So part of my job is to help you identify, where do we have to file this? Is it worth the cost? What's it going to get you at the end? Are you really willing to file a lawsuit in China, for example? Maybe, maybe not, right? And so a lot of my discussions with clients are about, where do you want to file? How aggressively do you want to police this? And how do we accomplish that? So a little more detail on the process. That 3 to 8 years is kind of summarized on this slide, and you'll see a lot of arrows going backwards, and that's because my strategy for you and for my clients is to make sure that patent pending process lasts as long as possible. Why? A couple reasons. One, we want to make sure that your patent portfolio is flexible for potential investors or buyers of your company. You will get paid a lot more money if you are still patent pending when your company gets acquired versus if you have fully matured issued patents. That seems counterintuitive, right? But I'll tell you why. If I'm a buyer of your patent portfolio and I know that I want to take that patent protection and sue company ABC, If your patents that have already granted and issued and are locked forever don't cover what A, B, and C is doing, that doesn't help me. That I'm not going to pay you nearly as much as if your patents are still flexible and in the pending phase where we can make some changes to it and push the protection, the fence lines in that first picture, we can push those fence lines to other territories, then I'm going to pay you a lot more because that means I can sue the pants off of ABC company on patents that I think are actually worth something. So generally speaking, again, it's very general, but you're likely to get paid more for acquisition of your company if you're still at least have something in the patent pending phase. So for many of my clients, we don't do that cycle once through that timeline on the previous slide. We do it over and over again. Every time they come up with the new version of their product or process, we ask ourselves, okay, is it worth filing another patent on it? You know, here's the expected cost, here's what it will get you, and that could be a patent pending piece of your portfolio that's going to really attract some investor, some buyer. And so my job is to keep this cycle going as long as possible for you, as economically as possible. Trademarks, very quickly. They're usually very inexpensive compared to patents. So you saw the typical costs of getting a patent. Trademarks, typically you can get those through the process in about a year. And typically the cost is a couple $1,000 on average. Sometimes a little less if things go smoothly, sometimes a little longer if they don't go smoothly. They are also country and region specific, just like patents, so your US trademark registration doesn't help you at all in Canada or Mexico or any of those other, even if we have a treaty with them, it doesn't help you. You've got to chase protection for your brand in Canada, you got to chase it in Mexico if you care about Mexico. Europe, same thing. But they do give you very broad protection for words and short phrases. So like McDonald's, we know immediately what comes to mind when we say McDonald's, right? Or Amazon, we've been using that example. Short phrases, oddly enough, McDonald's has never filed for a trademark on I'm loving it. Isn't that funny? They've been using that for decades and they've never filed for trademark protection, but they probably could at this point get protection for the phrase I'm loving it.
Why didn't they?
I don't know. That's a great question. There's a possibility it's because it's so ubiquitous and everybody uses it and they've translated into all these languages that why bother with the expense? Is anybody really going to start calling their fast food service I'm loving it?
Yeah.
Probably not, right? So they may have just made the decision it's not worth doing it. And famous brand companies will often take that route of we're just not going to bother.
Yeah.
We'll protect our main brand, our product line brands, and after that, yeah, who
And they
cares?
probably can change their tagline slogan
Oh yeah.
all the time, right?
That's another thing. They may not have thought it was going to catch on when they started using it, and it became the thing, right? So no requirement like the patent system of protecting before you use. In fact, trademark protection requires you to use it in public, so often it's cheaper and easier to get the protection after you've started selling products and services using that brand. The danger there is if you print product packaging with your brand on it before you go through this process, you may not get protection for that brand. You may have to reprint all your packaging at some point. So there is a kind of a double-edged sword there, but the protection for trademarks comes from a part of the Constitution that requires interstate sales or sales of the services or advertisement of the services across state lines. And so, because of that, there's a requirement in trademark law, unlike patents, where you have to actively use your branding in open commerce in order to get or keep that protection. Trademarks can last forever, unlike patents, so it's not a 20-year limit on your protection. It can, as long as you keep using it, you can keep protecting it. So there are some famous brands in the U.S. that have been around since pretty much our country founded, and as long as those companies keep using them, they can keep protecting their brands that way. I get a lot of calls. I have a new logo. I need to protect that as a trademark. Okay, great. Show me the logo, and it's just the name of the company in fancy letters, right? Can you do that as a logo? Sure. Why would you want to? I don't know. There's no real benefit. If I protect, and I haven't done this yet either, if I protect Incubate IP from my law firm as the words, what extra protection does the logo get me? Not much, right? I can only chase someone who's using Incubate IP with this weird little cracking egg thing, and who's going to do that? So it doesn't really help me out very much to file for a trademark protection on the logo, since my logo's got the words in it. I'm just going to protect the words. But sometimes that's an option if you can't get protection for the words. but where I see logos being filed for trademark protection right now is the icons on iPhone screens, right? So the Uber is the black circle, the black square with the U in it, right? Spotify is the green thing with the black, I don't know what you call it, the radio, the arcs, the black radio frequency kind of thing. Those are great things to protect with trademarks because there's no words in them. So, the logo actually does bring them extra protection. So that if another company comes out with a car sharing service and puts a red square with a U in it, you can bet Uber's going to be all over that. You better rebrand or else we're coming after you. So that you can get some mileage out of that if you're a digital tech company, and putting your app up on the iPhone store or the Android Play Store. Protecting that icon through a trademark can be a good thing. And this is where I spend a lot of my time. So you cannot get trademark protection for words or phrases that are generic. So like aspirin used to be a trademark, owned by Bayer. It's no longer a trademark because we just call that product aspirin. Whatever the brand is, we call it aspirin, right? Windows is fairly descriptive of what it is, right? The original software, for those of you that are as old as me, actually literally opened up Windows, and so they're like, you can't protect that with the trademark. Now you see a little circle R, they have protected it with a trademark at this point, and I'll tell you how they did that. But on the scale of things, the Trademark Office does not give you protection for anything generic. Will only give you some protection for the descriptive stuff. If your brand just describes what your product or service is or does, it doesn't help, right? Suggestive, so Greyhound for busing services. Greyhounds are pretty fast, right? And so the whole connotation there that Greyhound was going for was, we'll race around the country for you and get you where you need to be, right? So that's a suggestive mark. You can definitely get protection for suggestive marks. And then fanciful and arbitrary is kind of the best one. So if you've ever noticed the drug commercials, all the new drugs that come out have weird names that aren't really words, that's because the drug companies want the strongest trademark protection possible. They do a lot of enforcement on their trademarks because they know if I'm selling a drug under the name Viagra and it does a job, and somebody else comes along with a drug that does the same job and calls it Ziagra, you picked that name on purpose to trade off of my goodwill, and so they do that on purpose. So Zymbalta and all these words that are totally made up, that's a category that the Trademark Office considers fanciful or arbitrary, things that they're not real words, right? Great protection for those on the far end of that spectrum. Won't get it for, I represented a company for a while called, I can't think of the name now. They were in a lawsuit against a company called Stem Cells Inc. What do you think that their technology was? Stem cells, right? And so do you think they were able to get protection for that brand? Heck no. No, that brand does exactly what your company says it does. That's totally descriptive of what you're doing. It's not going to happen. So how did Windows get their protection for this? Over time, you can get protection for descriptive terms if you're the only one using it, and over time your customers go, oh, Windows, I know that's, what's his name's company, and I use them with DOS or whatever the operating system is called now, Windows 10, right? So over time you can build enough brand awareness that your customers automatically think of you when they think of the word Windows in that product category. That's how they got that. Bayer, like I said, had aspirin as a registered trademark. They lost it. How did they lose that? They stopped using it as a trademark, or they stopped policing other people using it. So as their competitors came on the market with the same compound, the same drug compound, and started calling it aspirin, Bayer didn't try to stop them from doing it. Same thing happened with the word escalator, by the way. That used to be a brand name that used to be protected by a trademark. And the company that had that brand made the fatal mistake of using that word, their brand, in all the specs for new buildings. So all the building codes, all the municipal codes that were being written around that time for how do we safely put this technology into new buildings, they were using the word escalator in the laws, in the regulations, in the municipal codes. And after a long time, that was just, well, we're calling that an escalator. That's an escalator. It doesn't matter who made it, that's just an escalator. And so they kind of sank their own ship on that one. And what used to be a suggestive, or for them, escalator, that would have been a suggestive mark, became a generic mark. Kleenex is very close to that, right? That's a brand name. That's a registered trademark, but everybody calls tissues Kleenex. And so they're in real danger of losing that. Xerox was the same way for a long time when Xerox machines were still around. And so, you can lose that protection. So the take-home message on this is getting your trademark is just part of the battle. You have to actively police it and make sure it's being used properly so that you don't lose that protection. But it can be great protection for startups and relatively simple and inexpensive to get. Copyrights, only message I got to give you here is there's 2 levels. There's free automatic copyright protection. As soon as, remember, we take that information, that thing out of your head and put it on paper, on a computer, on a canvas, on a whatever, you get automatic free protection of that as a copyright. You don't have to do anything. It helps if you put the little notice on the bottom. You see it on books all the time. See the year and your name. That's great. That's a copyright notice, but you don't even have to do that. What you can do with that is very limited, though. You can pretty much only stop somebody else from making copies of it and selling them without your permission. A registered copyright gives you a lot more power. In the federal laws, you can sue people for money, for lost revenues, things like that. There's even a provision that if you can't prove that up, you can get an automatic per copy fee from the infringer, and you don't really have to prove much of anything. But with any of those, it's relatively inexpensive to get. I only recommend filing for copyright protection on stuff that you're going to try to actively license out. So I have a client who's a visual artist, paints things, and wants to license those out to be put on fabric. Okay, great. Let's file for those. That's easy to do. Then you have something you can show off to your potential clients, and we can write in a copyright license for you that's a registered asset. And then finally, trade secrets. It's super cheap and easy. We've talked about this enough. One thing to note that we haven't really talked about is that your patent application that has not yet published can be considered a trade secret because it's still secret, right? Once it publishes, that evaporates immediately. But patent applications don't publish for 18 months from your first filing. So you've got about 1.5 years of treating that as a trade secret technology, even though you've taken a step to patent it. The other thing, that kind of the classic example of a trade secret is Google's search algorithm. Nobody knows what that, I don't even think Google knows what that is anymore. It's kind of breathed a life of its own. But since they're not publishing it, they're not disclosing it, they're not letting anybody reverse engineer it, that's a good example of a trade secret too. Thanks for coming. Appreciate you braving the cold weather. And our contact info is also on the slides here, so if you have questions afterwards and don't want to air your laundry in front of everybody else, that's fine too. We're happy to chat with you on the phone.